Mr. Bagnell, seconded by Mr. Graham, moves that C-235, an act to amend the Criminal Code and the Corrections and Conditional Release Act, fetal alcohol sin disorder, be now read a second time and referred to the Standing Committee on Justice and Human Rights. Debate. The honourable member for Yukon.
Merci, Monsieur le Président. Ça me fait un grand plaisir d'être ici aujourd'hui on the traditional territory of the Algonquin people. I have moved today to start the debate on C-235, my bill on an act to amend the Criminal Code and Corrections and Conditional Release Act, fetal alcohol disorder. We have all seen television episodes of someone wrongly imprisoned and how that devastates their life, how heartbreaking it is. And I'm sure it's moved many of you to tears. Colleagues, we have it in our power with Bill C-235 to end the number of cases of needless suffering of innocence. Not one, not two, not three, but potentially over 2,000 cases a year. In fact, for people alive in Canada today, that could potentially affect 180,000 Canadians. Is this not an immense challenge and humanitarian opportunity? First, I'll explain this bill briefly. FASD, fetal alcohol spectrum disorder, is a permanent brain damage caused by prenatal exposure to alcohol. In a vast majority of cases, unlike other ailments, it's an invisible affliction. Symptoms, among other results of the central nervous system defects, are impaired mental functioning, poor executive functioning, memory problems, impaired judgment, inability to control impulsive behavior, and impaired ability to understand the consequences of one's actions. These are a distinct set of attributes capably diagnosed by today's modern assessments. Through no fault of their own, the brain they were born with does not have the ability to keep them from committing crimes or understanding the consequences. So normal sentencing, normal incarceration, normal release doesn't make any logical sense and does not fulfill the purposes for which they were created. So this bill is simply comprised of 4 recommendations from the Canadian Bar Association, the thousands of lawyers and judges who deal with this affliction every day. First, it just allows the court to order assessments of an offender to see if they have FASD. Second, if they have FASD, it allows them to use that as a mitigating factor in sentencing. Third, when a person with FASD is in custody, the bill directs it they be treated specially for that, and it just adds to a list of other conditions and groups of people treated specially in the correctional system. And fourth, when the person is released, a person with FASD, they would have an external support plan so that they don't, for instance, miss probation and just end up, as the judges say, through the revolving door back in prison. Simple, prima facie, it appears so. But many bills can be improved in committee, and I welcome any logical amendments to this bill. My goal is to reduce unnecessary, tragic human suffering. But some may want to know the financial savings. Assessments cost in the order of $5,000. But if Ontario were to keep 1/2 of the yearly potential 840 FASD offenders out of jail for just 1 year, at $100,000 a year, they would give them over $40 million a year for more logical, just, humane, effective ways of dealing with these offenders and their afflictions. It is important to note that in the last Parliament, similar in some ways, identical bills to this one almost, were twice before the Parliament, one Conservative and one Liberal, but they didn't have time to complete the legislative cycle. Upcoming, you will hear some of the excerpts from that debate. Speakers from all parties supported and spoke in favor of that bill. It's important to recognize that this bill is only a small piece of the much larger puzzle of steps needed to be taken to alleviate the suffering and sometimes tortured existence of people with FASD. Other steps that need to be taken included prevention. This is a totally preventable condition. Steps to prevent contact with the justice system in the first place. Further research, special services, restorative justice, information sharing, targeted interventions, interventions, and supportive living arrangements. These are important tasks for others, but this bill only deals with FASD sufferers who have an interface with the justice system, and that is about 60%. Yes, I said 60%. As I outlined at the beginning, as you can see, the need is staggering. Estimates are that 1 in 100 Canadians are afflicted with FASD, and studies indicated that minimally between 10 and 30% of inmates in today's prisons have FASD, costing us tens of millions of dollars. This is perhaps why call to action number 34 of the Truth and Reconciliation Commission calls on the governments of Canada, the provinces, and the territories to, quote, undertake reforms to the criminal justice system to better address the needs of offenders with FASD, end quote. Now, as I said, I'm open to amendments, and I'll just give you 4 items that people might want to debate in committee. First one, should the judge have the power to make assessments mandatory? There are mixed views on this. There are already precedents in the criminal justice system for ordering assessments, but if parliamentarians feel these should be not mandatory, then it's easy to amend the bill. We do have to protect the offender from self-incrimination during these assessments. If parliamentarians wanted, they could also expand the assessment section to clarify criminal code assessment power in general, and then that would also just include FASD assessments. To the credit of the territories and provinces, assessments are much more widely available now than in the past. Second item of discussion in committee. People might want in committee. What about people with other afflictions who are not included in this bill? First, they are not filling our jail in the thousands like FASD offenders. Second, if there was a big need and other identified affliction needing special conditions that could be prescribed, someone would have proposed legislative remedies for that situation. Third, most other conditions are visible and otherwise known to the judge. FASD is known as the invisible affliction because until diagnosed, many people, including judges, would not know the offender had FASD and impaired brain and central nervous functioning. Some have high IQs, but still have the interaction deficiencies that I outlined at the beginning of my speech. And fourth, if another condition and its deficiencies and special provisions were presented to the committee, they could easily be added to the bill now or to the criminal code at a later date. But to date, there's no serious evidence having been presented to us of another condition with near the magnitude of problem in our present-day justice system as identified by lawyers, judges, and FASD workers across Canada. A third item to discuss. What if in the rare violent offender FASD cases, the assessment results in the offender being put in protective custody for a longer time than would have occurred without the assessment for the safety of both himself and the public? I say, so be it. As an evidence-based government, it is better to have more evidence to make a decision. And the last item we might discuss, amongst others, is should the external support plan be approved by the judge or the probation officer, and should it be voluntary after the time of a normal sentence of a person that does not have FASD? So those are 4 items we could discuss. As I said, I'm open for amendments. But we can save thousands if we act now from injustice and needless suffering. Perhaps in the future we could even add a few more if the condition and its legislative remedies are identified and documented. But there's no reason to delay. If in fact someone launched and won a challenge and were added to the criminal justice system, then our pioneering efforts would have paved the way for that to happen, for that person or that group to have justice too. There's a huge desire from MPs on all sides of the House to improve greatly our dealing with mental health issues in Canada. What a great humanitarian advance if we could improve the lives of thousands with this mental deficiency. It goes without saying that in Canada, in fact around the world, there's great support for legislative assistance for people afflicted with FASD who come in contact with the legal system. When the similar bill was before Parliament, the Conservative proponent said he had 1,500 stakeholders supporting his efforts. I have my own large network of support. The Conservative member also said on June 5, 2014, and I quote from Hansard, I would also like to extend my gratitude to the legislatures of the Yukon Territory and Northwest Territory, both of which passed unanimous motions calling on the government to support the bill. Some FSD workers in other countries applaud Canada for these pioneering efforts and want to use them as models in their own nation. But it's not only FASD experts in the field that are so passionate and excited about this bill. Remember that this bill is different from a lot of normal private members' bills that may not have a legislative background. This bill is comprised only of the 4 recommendations from the Canadian Bar Association and its president at the time, Rod Snow, and thousands of its member lawyers, legal experts, and judges who deal constantly in the courts and corrections system with offenders with FASD. Who better to craft a legislative improvement? The purpose of sentencing is to protect the public by presenting a deterrent to the offender so that when he or she gets out, which virtually all of them do, they don't reoffend. But the damaged brain of an FASD offender often does not connect the crime with the punishment. So if they don't know why they're being punished, why would we continuously, cruelly, senselessly incarcerate them at the cost of tens of millions of dollars instead of treating and supervising them appropriately on the basis of the reality of the sad truth of their physical brain deficiency? Now, I want to quote from the Conservative speech again from Hansard when the bill was before Parliament on June 5, 2014. It is a quote from a young FASD woman speaking at a conference. Quote, "She talked about going to work in the morning and forgetting her keys and then returning home to get her keys, but then forgetting why she had come home. Then when she finally realized that she was looking for her keys, she forgot what she needed her keys for. She had to slow down, calm herself, and deal with the confusion and frustration of not being able to really grasp exactly what she needed to get done." End quote. Imagine this young woman tasked with making a number of probation or court appearances or appointments. And what happens if she misses an appointment? Back to jail, an administrative breach. With a damaged nervous system, with little concept of timing, we are irrationally, unjustly ordering people to painful personal purgatory. Our current federal justice minister said it as well as anyone I have heard when she said to the Canadian Bar Association last February, "The truth is many offenders have some combination of mental illness and addiction. Imagine if we could change the system to better align it with the needs of Canadians. What if an offender's first interaction with the criminal justice system did not become the first in a series? What if it triggered mechanisms designed to address the factors that inspired the criminal behavior in the first place?" End quote. It's been a long day. Let's go home. Just imagine you're going home. But what if you, after you walked a couple of blocks from here, you were picked up by the police and put in jail for a couple of years, to your horror, far from your friends and family, and you didn't know why? And when your time was up, you got out of this horrible situation, and then you were picked up by a police car again, and they were told, "Oh, you missed an appointment," and you were thrown back in jail. You would wonder how people could be so cruel. Colleagues, let us show what it means to be Canadian and end the suffering of thousands who, through no fault of their own, cannot help themselves. Thank you.